Ms. Robertson, I just wanted to ask you analytically, and I'll show my cards and say it just because of thinking about this DIG argument. Do you think analytically we should be thinking about these as two distinct statutes, or should we be thinking about the VWPA and the MVRA as just different amendments to the same basic statute?
We think that you can think today of both Section 3663 and 3663A as part of the MVRA because restitution imposed under either scheme would be subject to all of the MVRA's many provisions, including its collection authorities, its procedural safeguards, and all of those provisions are relevant to the court's analysis. But to be direct about the DIG, if the court wants to identify the provision at issue here, we do think it should take the case on the premise that it's Section 3663A. That was the government's position before the Court of Appeals. The Court of Appeals accepted that premise. Petitioners no longer disputing it or asking this court to revisit that factual predicate. And so we think it's appropriate for the court to resolve this case on the same basis that we asked the Eighth Circuit to rule in our favor below.
And that section was not in effect when he committed the crime, correct?
That's correct. So
that's the source of the ex post facto problem. No matter what happened at sentencing, at the time he committed the crime, 3663A was not in effect, and today he's being held to account under that provision.
That's correct, Justice Jackson. I would make one clarification. The MVRA by its terms applied to petitioner. So if the district court didn't apply 3663A, it could have only done so if it determined that that provision was criminal punishment, the very question at issue here. Now, there would be a separate question as to whether the limitations period that the government is currently attempting to apply to petitioner might constitutionally apply. It's our position that it could, even though his restitution obligation was criminal punishment, because we don't think increasing the time to collect restitution increases his punishment.
That's the argument you want to preserve.
But that's the argument we're trying to preserve for remand.
Can I just go back to Justice Alito's colloquy with you? Because I guess I'm still wondering whether your argument flows from the idea that there might be different purposes of punishment and that you could have a punitive measure that is imposed for rehabilitative circumstances, and with an idea that you are making this person pay back society, you're making this person make amends for what it is that he's done, but it really is still a part of the punishment in the way that theorists have traditionally understood various purposes of punishment.
We think that's right, and this court made a similar observation in Kelly itself, where it said that restitution serves as a particularly effective rehabilitative penalty precisely because it forces the offender to confront in concrete terms the harms that his actions have caused to a real person, more than a fine, which is paid to an abstract entity like the state would. It also serves a particularly effective deterrent purpose for that reason, by closely aligning the punishment that the defendant faces with the harm that he's caused.
So even if it's victim focused, it can still be punitive in this way.
Yes, absolutely. And we do think that this punishment here serves penological goals as well as compensatory ones.
Thank you.